Okay, we'll start with the issue of spousal support and the factors that are to be considered and whether to award maintenance support. The duration of the marriage, we're talking about 17 years. Age of the parties, 41 and 42 respectively. The health of the parties is kind of a pretty pertinent factor here. Husband is in good health, wife is not, and has not been for quite some time, has been dealing with chronic issues essentially almost all of her adult life. And we did hear professionals testify to the difficulties that she faces and what effect that might have on someone's ability to maintain regular, consistent, full-time employment. This has been an issue for her. She's never been able to maintain full-time, consistent employment more than maybe a few months at a time, or a chunk of time here and there. And she's also dealing with the physical after effects of the stroke that she unfortunately recently suffered, which is compounding the mental health issues that she's dealing with. The standard of living established. Husband gets to stay in a nice home that the parties lived in together. Wife is living in a home with 6 people total, and ultimately is going to have to find someplace else to live. And rent is really high right now. She and her USD is projecting that she's going to pay at least $2,000 in rent once she moves out of the Elijahs, and it's just not sustainable for her to stay there. In order for her to maintain a comparable standard of living, she's going to need some significant support. The relative income and earning capacities, it sounds like we've heard testimony that husband's income is roughly $11,000 a month. The only income that wife currently has is the $898 in disability. And she does get some food stamps as well.
$898 plus.
For the food stamps?
No. Wasn't it $898 plus? I think she.
Oh, the cost of living.
The cost of living.
That's right.
I didn't see that anyone did that math, or where they were expecting me to. What was the percentage?
It's 8.71%.
That never really came into evidence. That was not into substantive evidence. It was a
She just knows her income's higher than what it was.
Right. And you made the statement, and I can pretend I didn't hear that it was 8.1%, but it technically isn't substantive evidence. It was a question.
Yeah.
All right, that's fine.
Okay.
Although I suppose since the parties have been really reasonable about agreeing on the things that are subject to agreement.
Yeah.
What would 8.1% of 898 produce?
8.71%.
Oh, 8.71, sorry.
Puts her at 976.
Okay, go ahead.
Yeah, parties training and employment skills. Again, wife has had stints of jobs here and there, but has never been able to maintain consistent employment to actually progress in a career. Well, husband for the past 23 years has been moving along and progressing in his military career, and is also working on his master's. The financial needs and resources of each party. I think wife is being pretty reasonable in what she anticipates she'll need to be able to live on her own and support her children. I think her USD has roughly $4,000 each month in expenses after factoring rent and utilities and all of the other living expenses in. And so in looking at the other cases where indefinite support was awarded, we have a lot of factual similarities where we're dealing with folks who have bipolar disorder, some sort of mental health issue, maybe ongoing health issues. And in those cases, the marriages weren't particularly long.
The shortest you said was 11?
Mm-hmm. Actually, no. In Ray marriage of Tim, they were married 8 years.
There was an indefinite award after an 8-year marriage?
Mm-hmm.
What was the age of the parties in that case?
The ages weren't mentioned.
I'll read it. That's
okay. And so I think in this case, an award of indefinite support is warranted just because there's no indication that wife is ever going to be able to work full-time and support herself. She may be able to work here and there to kind of supplement her income, but she's not going to get to a point where she's fully self-sufficient and is making an income to support herself and her children. And then I will move on to the property issues. There's a case, in re marriage of Chrislip, 86 Orab 146, that talks about the valuation of the marital property to happen at the date of dissolution, even after there's been a longer or some length of separation. In that case, there was a 30-month separation before the divorce, but the distribution included the increase in the value attributable both to new investments and from growth in pre-separation investments for the husband's pension. And in order for the court to, the case law says that in order for the court to apply the value of the marital assets at the date of separation, the parties have to have a lengthy separation and be fully financially disentangled. The parties are working towards that here, but wife is not fully disentangled from husband yet. There's a number of assets that need to be disentangled that have not been. And so our argument is that the marital assets need to be valued as of the date of the dissolution, which is standard practice in Oregon. And again, we would request that husband have in his column the 3698 tax return that he received credit for towards his arrears.
That's line 29.
30.
I say 30. Oh.
And then we would request that the reimbursement that wife received for the stolen camera not be included in her column, just because each party has taken personal property and we're not going through everything that was in the house and itemizing everything. So if we're gonna itemize the camera, then we need to itemize all of the property that's still at the home. And so I think the easiest way to handle that is just not include it in wife's column. And then, I think lastly, the biggest issue is the inclusion of, 41,000, tallying up all of the credit card, charges that wife made in order to support herself before she was receiving support. And so I think a fair and reasonable way, or fair and equitable way to address that is to give husband credit for the difference between 2838 and the amount that wife incurred on the credit card for that period of time, because she is entitled to some support. Husband 2838. She was entitled to some support before the child support and the spousal support started accruing.
Remind me, 2838, is that the total sum currently?
Yes.
Okay. And then subtract that by month from each of those columns. That still leaves the question of which column to accept, hers or
Right.
yours. I mean, I don't mean column as far as the
total amount for each month.
I meant within the exhibits themselves, right? You're far apart on your credit card. He itemized each list, and I haven't heard a response from you in your argument. I'm just inviting you to argue about his yellow and green columns.
without having reviewed every single line, I can't respond because I haven't had a chance to review every line with my client. We weren't aware that it had been itemized like that.
All right, if you were correct, and I'm not asking you to make that concession, but if you were correct, then you're asking me to subtract 2838 monthly from
Correct.
From their son.
Correct.
Okay. Up until the court's order, is that right? And that was in October.
July for
Oh, was it retroactive?
child support, and then October for spousal.
I'm slowing you down, I'm sorry.
No, you're fine, and I think I covered everything in the asset and liability spreadsheet, and so we're requesting indefinite support in the amount of $2,000, and for Your Honor to adopt the figures that we just reviewed in the asset and liability spreadsheet.
My computer is frozen again. Before you call IT, let me try something. I don't want to close this out without saving my work. We have no IT today.
Oh, spare pen.
Government. Why do I work for government? Okay. Okay, I know you think you're done. You're not done quite yet.
Yeah.
What's that? Did you raise your hand?
Okay.
Yeah. Okay, so if I'm going back, let's separate those numbers out. So if it is 2338,
2838.
I'm sorry, I wrote 2838. I just read it wrong. If it's 2838, separate that into child support, and so that if I go back to July,
Child support amount was $1472.
and my spousal was
1600.
16, no, okay.
Well, when the spousal support started in October, the child support amount dropped to $1238.
Okay. To 1230?
38.
38, okay. Thanks for doing that for me. Counsel, Ms. Brown.
My turn?
Yeah, you can stand or sit as you like.
No, I can't sit and do this. I just wanted to point out that Mr. Roskin has come here today quite reasonable. This is a man who continued paying all of the marital debt, has paid support when told to pay it, and he's not taken an unreasonable position when you come here today. Now, I could point out some case law that supports. I add up everything he's paid post-separation on that marital debt and add that onto this. He hasn't done that. He's not asking for reimbursement of that.
You're asking for a zero equalizing judgment.
I am, Your Honor. I am. Because that's what's just and equitable. With regard to the spousal support, a lot of guys would come in and say, it should be zero spousal support. She has to take care of herself. At no point in time have we said zero spousal support. We have come in here with a very reasonable figure based on case law we presented to the court. One thing I wanted to point out with regard to some of the precedent that council's pointed out, that was before the 2019 tax law changes. Now, in my trial memorandum, I did do a table for the court on some of the spousal support cases that I picked out, that I liked.
You'll forgive me for not having read it since you filed it.
Oh, that's okay.
this
You
morning.
can, yeah.
All right.
No worries. It's page 7. We picked some cases on point with regard to close on income, length of marriage, things of the like. All right. Now, in 2019, there was a tax law change. And
I'm aware of that.
okay, good.
And that's only one of the factors that the court considers.
But what I've seen, Your Honor, is a trend. Now, we really don't have appellate court cases on it yet. But think of it this way. He had income, spousal support. All this precedent is based upon minus, we'll say 24%, that's what I use, because he gets deducted, and add 24% because she has to pay taxes on it, okay? So now we're in a situation that all those spousal support numbers would come down based upon the fact that the tax burden has shifted.
I understand that. I guess my question is, do any of these cases address the issue that's a little more novel for me? I've read a lot of spousal support case law. It's one of the more stressful parts of this job because there's no guidelines as you see in other.
It's all across the board. She can pick cases she likes. I can pick cases I like. It supports our positions.
Do any of your cases feature a scenario where there's a claim of indefinite disability that would prevent work?
I will tell you, Your Honor, there's cases to support either position on that. Candid to the court. There's cases that will say indefinite because this person's disabled. There's cases that say not indefinite because it's expected this person should reach a level of self-sufficiency, or the disability is not bad enough, or this is a short-term marriage. There are cases both directions on that. And so as judge, it's like, what passes the smell test? Which cases do I like best? And I don't know how judges do that, but that's essentially what you're left with. I will point out in remarriage of Tim that we didn't have the ages, and we still don't have the ages. The maintenance support was $300 per month. So we're not talking about some kind of substantial support award. I'll also point out to the court that though we don't know her age, she had multiple sclerosis, which is a health condition that inevitably will get worse and will shorten the life expectancy. So we're not dealing with a Tim type of situation with a multiple sclerosis case, which quite frankly is a wild card case to see indefinite support on that short of a length of marriage. But nonetheless, with regard to the taxes, I don't want to be a dead horse with it, but something that would have been $1,000 a month pre-2019 would be equivalent to $760 a month post-2019 because of that tax law shift. And that's what you see with spousal support awards, is they've come down because it's essentially tax-free money. What we're looking at, Your Honor, at the end of the day, and this is set forth in my memorandum, with our proposal, wife has $4,061 per month. She doesn't have any consumer debt. I know she's claiming she owes a friend money at this point in time. She doesn't have a car payment. At this point, she doesn't even have a housing payment. She has minimal monthly expenses. And that gives her, without even leaving the house, $4,061 per month.
That's inclusive of child support, though.
It is, Your Honor, it is. And if you look at these cases, when you've got the child support built into it, you're going to see the lower spousal support because they look at the combined pot. So nonetheless, that gives her $4,000 a month without even leaving the house. Now, her uniform support declaration doesn't even have a need or show a need that's even that high. She claims the $500 a month car payment, but her car has been paid off by Mr. Roskens. She claims $2,000 in rent, which is an expense I really didn't hear concretely that she ever paid. In fact, she said she was paying $1,350 a month, $1,600, maybe $2,000. Oh, I paid utilities on top of that. But when you talk to her friend, no, the utilities were included in that money that she's paid each month. And there was no discovery provided. Nothing provided. No bank statements, nothing showing these expenditures in the first place. So my point is, Your Honor, that is a sufficient level of income to more than meet her basic needs. By contrast, you have Mr. Roskens, who is working day in, day out, working extensively, doesn't have the luxury of staying home. And he has $4,700 a month towards the marital debt and the mortgage that he's paying on a monthly basis. Then he'd have the $2,722 a month for proposed support, and that leaves $2,835 per month. And that's, it's actually $350 less than that because we learned today that he's going to lose part of that CPay. So that gives her $4,000 a month without even stepping outside, him working day in, day out, and that comes out to $2,500.
Do I also consider the inevitability that was talked about by Miss Elijah, that within either a year or at the max, it sounded like 2 years, the scenario would inevitably be that the children and wife would be out, and that their expenses would necessarily grow.
Still fits within her budget because she already claimed it, Your Honor. If you look at her uniform support declaration, she claims monthly expenses of $35.94, but she doesn't have that car payment of $500. So even with $2,000 a month and these utility charges, her claimed need is $3,094 a month, giving her a surplus of over $1,000 a month to work with. And in the meantime, Mr. Roskin is working with a deficit. So that has already been taken into account with the uniform support declaration.
Well, it's 1,000 more. It could be more if the court imputes to her some income, and the court hasn't made a decision about that. But right, meaning that the $4,600 per month is your proposal. That's
4,000.
Oh, it's just 4. I thought it was 46.
It's 4,061.
Oh.
She actually has more than that because the COLA wasn't worked into that when I did the calculation. And that's without even imputing her any income. You're correct, Your Honor. Now, should she pick up some substitute teaching work, which she's certainly capable and able to do and has done in the past, that can work with her disability and her on-call schedule, she has more than that on a monthly basis. The ball's in her court, but what I'm saying is just with the amount of support we've proposed, she has more than enough money to make ends meet on a monthly basis. And the court looks at standard of living that was during the marriage. You have to look at how you got to that standard of living. There's case law, which I presented in my memorandum. If the parties are overextending themselves on a monthly basis, living off of credit cards to support their lifestyle, that's not something that the courts acknowledge needs to continue. The court looks at what should they have spent? What should their lifestyle have been? We can't keep someone in a lifestyle that was above everybody's means, especially on an indefinite term like she's proposing. What we've presented here is fair and reasonable, and frankly leaves Mr. Roskens with less money than Ms. Roskens, even though he's the one that's doing all the work. He's the one that has to carry the tax burden on all of this, where she has her money tax-free. And that's what's just and equitable, Your Honor, is this $1,300 per month. I'm hearing from Ms. Roskens that she's going to school. Great. I hear that she got invited for an interview for a job. Great. But I'm not hearing the follow-through. And why not the follow-through? Because she doesn't have to. She doesn't have to set a goal at this point in time. She doesn't have to have motivation to do anything because Mr. Roskens is fully supporting all of her claim need on her uniform support declaration. So if we continue with this path that's been set on a temporary basis, and it was supposed to be a temporary order, but if you continue on that path, she doesn't have incentive and motivation. Call it tough love if you will, Your Honor, but she needs some motivation. She needs to know that, I've got to get up in the morning, one foot in front of the other. I got to get this together. And that leads me to these medical providers and counselors that, quite frankly, were cherry-picked and probably don't have a lot of relevance as to what's going on right now. We have Dr. Anderson, who last treated her January of 2023. Even though Ms. Roskens has degenerative disc disease, it hasn't hurt her since 2015, major depression, PTSD, as of her last visit with that physician, she was going through a divorce. She was doing well, happy about a recent child support case. She was going to school, enjoying her studies, and living with a friend. From Dr. Anderson, I didn't hear anything saying that Ms. Roskens is in the state where she can't do anything. In fact, the doctor said, when you remove stressors, people typically function better. People with these conditions can work. They have their good years, their bad years, their good days, and their bad days. But, Your Honor, she reported that she was doing well at that point in time, and we heard nothing from any physician since. She claims she has a stroke. I'm not doubting she had a stroke, Your Honor. And I've heard she's had improvement as she's moved along. But for a long-term prognosis, there is nothing in the record, nothing stating that she's not going to obtain her pre-stroke level of abilities. Then we have the counselor, Your Honor, and I have a lot of issues with that. Everything the counselor said was based on self-report by Ms. Roskens, based on her answers to questions. So then when I asked the counselor about that, well, that and her demeanor and her attitude. Well, Your Honor, this is all subjective. Somebody can go into a counselor and say whatever they want to get the answer that they want. There is no independent verification. There's nothing separate from that. And I find highly suspect the 2 dates of the eval, Your Honor. We have the first assessment 4 days after Ms. Roskens filed for dissolution of marriage. That's when your stresses are going to be at an all-time high, Your Honor. You just filed for divorce. There's no doubt your stressors are going to be high at that point in time. And then we have the second one last night, the eve of trial. There's a line that Judge McHill uses that I always get a kick out of when he says it. And he says, at the conclusion of a settlement conference where people settle, he says, I've never done a trial where somebody says, gee, that was fun. I wish I could do that again. It's not fun, Your Honor. The stressors for every client going into a trial, the day before trial, it's tough. I mean, that's one of the hardest days of your life. Tonight, they'll probably sleep well. But leading up to today, with not knowing what to expect when you step in that courtroom and how bad it's going to be, it's as bad as it gets. And that's the day she chooses to do an evaluation after not seeing this treatment provider for a year and a half. Highly suspect. And then you have her friend. Well, how was she yesterday? The day she does the eval, day before court. It was excruciatingly difficult on her. It was a hard day, a stressful day. Of course it was, Your Honor. Which frankly makes the result of any assessment done yesterday unreliable.
How much weight do I give to an SSD award?
SSI.
Do I give some credibility to the fact that she's already been deemed by another government agency to have a qualifying disability?
Absolutely. And I point out to the court, she has had that qualifying disability, but yet she's been able to have employment. She's been able to take care of her children, take care of her house, substitute teach, have various jobs, do photography shoots. So even with that disability rating, that doesn't mean that she can't do anything else. In fact, the proof's in the pudding. She has done other things. She doesn't want to right now because we're posturing up for court. But she has and she can. All the way up until these parties separate. She's working as a substitute teacher. She comes to Oregon. She doesn't substitute teach anymore. In fact, she applies. They invite her for an interview, and she doesn't go. I mean, it's as good as it gets, Your Honor. It's an on-call job. If she's having a bad day, she doesn't have to go. If she's having a good day, she does go. But nonetheless, it supplements her income. I'm not buying it, Your Honor, that she has no ability whatsoever to financially support herself. But even if she's completely disabled, she can't get out of bed, nothing else, she doesn't have to, because between what she gets, what he gives her, she's got $4,100 a month. So fully disabled that she can't work in supplementary income or not, you get to the same result, Your Honor. And again, this is where husband is living at a deficit each month, trying to whittle away at that credit card debt that they accumulated together. But it's going to take him a very long time because of what he has to pay out, not only to her, but to these bills on a monthly basis. I also have difficulty, Your Honor, with some of the calculated things done in this case. You have someone who conveniently goes in for evals right after she files for divorce and the day before trial. You have someone who continues using the credit cards in the checking account. You have someone who files for non-support against her spouse, even though she's been using the credit cards, taking money out of the bank account, files for non-support. So he promptly pays support at the request of the attorney while DCS is getting things together. And she comes into court and files a stalking order because he paid her directly. Then makes these reports to put him back on ship for an investigation, where he has a higher income, skating us right into trial so that she can make these claims. I'm not doubting she has the mental health issues, Your Honor, but there's too many things that are too calculated in this case that, frankly, give me pause. Turning to the asset and liability sheet, Your Honor. I always like it when something comes together, and conveniently, through no planning of me, it came together. On line 5, the value is $462,500. That is what was presented by wife's realtor. We really didn't have any evidence to rebut that.
What did you say, for what?
$462,500. And Your Honor,
How did you come to that number? That's the number I came to, but I did that on my own.
it was the as-is condition of the house, and it was
And
the
then you just
median
went
point.
with the median point.
Right in the middle.
Yeah,
Yeah.
okay.
Yeah, and you know what, Your Honor, I understand it's higher than we want to use, but that is the number that should be used. She didn't know how much the repairs would cost. Why should husband have to go through and make these repairs? That is the value of the house.
I thought you climbed up here and looked at my notes.
I could have when you weren't looking.
Well, I took my hand as the one finding, but you keep going.
Okay. Then we have line 6. The evidence is clear that husband has been the one, alone, paying this mortgage since the separation. And there's likely been appreciation in value of the home during the separation when he was making those payments. And he's preserved that, but he's not asking for reimbursement of those payments he's made. Again, the reasonable approach that we're taking here. All he's asking for is, you use the value of that debt at separation because she hasn't been making any contributions since. And that's how you come out to the net of You take the $462,500 and you take off the $367,990. And if my formula is correct, it comes out to net equity of $94,510 for line 10.
94 what?
510.
All right.
That looks right. Okay. We've got the thrift savings plan, Your Honor. Not much difference there. Nonetheless, he did contribute to it post-separation from his separate funds. She wasn't contributing at that point in time. And we've got that as husband's column with, of course, the anticipated tax consequences. And it looks like counsel and I have used the same rate. Nonetheless, $1,500 difference. I'm not worried about that. The Roth IRA, we've agreed that goes in the husband's column. We've agreed on the values. When you add those together, Your Honor, you're at the $65,967 for line 22.
If you concede her number at 67472,
That's what she has.
but I thought you just conceded her number.
I didn't concede it, Your Honor. I'm just saying it's not very far apart. It comes together better under my side. I'll show you in the end.
All right.
Okay. Then we have lines 24 through 27. Now, I note that the parties were still living together in November, December until January 18th. Husband was putting his funds into the account. Wife was using the account. He hasn't asserted that as a credit on his chart. Those were revolving accounts where the balances were up, the balances were down because they were used every month. So no value on those accounts. Those are just an X. They used that money for those marital expenses during that period of time. Your Honor, you have the tax refund that went towards credit card debt pursuant to the agreement. Then you have the tax refund, where it sounds like wife is saying $1,800 of that is hers, $1,800 should go on her column. That may be the case, Your Honor, but it doesn't change things enough in the formula and the values to really make that much of a difference. You have line 31. And there I put $500 on husband's side for the tools. You've got the 5988 for the 2 checks that wife received post-separation. Otherwise, they each got some personal property, nothing of substantial value, and those were equal.
I'm sorry, back up.
Yeah,
I'm still looking at the camera. The 500 represented his testimony
The
about the
tools.
tools? Okay.
which was above and beyond their split of personal property.
All right, so in order to side with you on that argument, I'd have to find that property division is essentially equal.
There was no evidence to the contrary.
Okay. Go ahead.
Okay. Here we have line 48. They had previously said the $25,000 was the value. Nonetheless, they say 21 today. Again, we're reasonable. We conceded that amount. Put the 21,400 in there. With regard to line 49, husband alone has been making the payments since the separation. The balance as of separation was $15,550. So that debt should go in his column because he's the one who's paid that debt.
That was all since separation.
Yeah, 15.5 was the balance at separation. He's paid it off and assumed a new loan.
Oh,
But nonetheless, she's getting a free and clear card. He's paid that off for her. You have the Nissan Altima. We agree on value. Line 53, yes, the car is paid off now, but at the time of separation, there was $3,816 owed on it. Husband alone made the payments post-separation. And I can tell you what that number is down there. So that has husband for 48 through 56 at negative 9,602. Wife at positive 21,400. Line 60 and line 61, it appears we're in agreement. Line 62, we have Exhibit 118 that shows us the amount as of the date of separation.
I'm sorry. You're in agreement on 1661?
We are.
Oh, I see. Okay, and then, okay, so you're at line 62?
62, we've got the Exhibit 118 that shows the balance of that debt at separation. And husband's been the one paying on it. So I'm not sure why it's in wife's column. And then we have 63 through 66, Your Honor, that we received no discovery on. I understand the position today was we received a credit report. We don't know, we don't have the history of those accounts. We don't know when it was accumulated. We don't know if it was pre-separation or post-separation. And there's been no evidence to the contrary indicating that would just be an X. When you get to line 68, that puts husband as negative $53,151. That gives husband $97,724 in totals for line 70. Wife, $27,388. For an equalizing judgment of $35,418 the husband owes wife.
All right, this is where I'm walk me through this.
Yeah. So when you add up all the totals on husband's column I and wife's column J, husband has $97,724.
Okay.
Wife has $27,388. The computer adds those together, divides them by 2. And husband owes wife $35,418. And Your Honor, here's where something unexpected came together. When you take the $41,532 that wife spent post-separation, the husband has been strapped with pain, you subtract off the $6,000 in child support arrears that are going to be satisfied in the judgment. Wife owes husband $35,632. I didn't plan that, but that's how it came out. They're $200 apart. And Your Honor, even if it was $10,000 apart or $15,000 apart, each has what's in their column and they go. They go their separate ways. When you're working with a spreadsheet, Your Honor, there's significant case law. There's not an exact science because you're doing what's just and equitable. I'm telling you that we've submitted this as an exact science, but if there's any minor errors in the math, you're still within the realm of just and equitable. You take your column, you take your column. Child support is satisfied. We're moving forward. Fresh start October 1st, 2023. Neither of these parties have debt in each other's name. Neither have assets in each other's name because she's going to sign a deed. He's going to pay her the $2,722 per month, and off they go. Easy, clean, divorced, done. Submit to the court, Your Honor. That's what's just and equitable. Thank you.
Okay. I want to thank the attorneys for your hard work, for the zeal, for a trial that was done in a day as promised. Thank you. And also the caliber of the attorneys today was high, and that's appreciated by the court. It makes life easier. I also appreciate the patience of the attorneys in adjusting to this particular magistrate, which I know it's not always easy, having been a trial attorney for years. So I'm grateful for that. Here's my intent, and I know that a lot of judges would take this under advisement, and I may very well do that. What I'm going to do now, though, is the methodology followed by Ms. Brown with respect to the assets and liabilities is so close, even down to my valuation of the home and my thinking even about small things about the camera and the $500, as well as the $6,000, which represented the difference. I found credible that testimony that he paid that and wasn't credited for that arrearage by the Division of Child Support. That math works for me. I don't know if that's a happy accident or if I have been looking at this wrong, but that portion of it makes sense to me, and I'm prepared to make rulings consistent with that right now. The question that remains and looms, and I'm not prepared to make a decision at the moment, is with respect to, and to me this might actually be the bigger issue with respect, I mean, if an indefinite award, we are arguing sometimes when we're talking about $500 with respect to a camera. These are small potatoes compared to a spousal. Frankly, I don't know, and I have no idea right now until I've read case law whether this should be an indefinite award, whether it should be in the amounts asked for, sought by petitioner, or those sought by Ms. Brown. I need to read some case law. I do have this memorandum, and I have a bunch of cases that were cited to me by Ms. Young, and I'd like to look at both of those carefully. I don't know how long it's going to take me to do that. So here's what I'm proposing. I do find, and I don't know, a more artful way of calling it a wash. I don't know what the legal term is with respect to the assets and liabilities, but I want to be really, really careful and not be so quick with respect to the maintenance analysis. There's also, I have extensive notes about the criteria that I need to go through. And I know that counsel went through them in her closing, but what I'd like to do is, it's currently 3:36. He came from Washington or San Diego?
He came from San Diego and he's headed to Washington.
All right, so I don't know whether I can get this done in an hour. I have my own kind of methodology with respect to how I calculate spousal support. I'm aware of a lot of different rules of thumb, and I typically apply those rules of thumb, produce various numbers, but I've never addressed really the issue of that's raised by Ms. Young about indefinite awards in certain circumstances. And so I really want to look at that case law and make some comparisons. And those numbers at the end, when you add those up, like I said, it makes all of this stuff look like small potatoes. If he's paying an indefinite award of $2,700 or whatever, well, I mean, that'd be the full. But I'm going to look at what's been what's been recommended. I think an hour should be sufficient. So if the parties could, I know you don't have anything else planned today. Are you willing to stick around for an hour just to wait? It might be the end result is I need more time at the end of that hour. So I want to warn you that I might be that rude with your time. But at the same time, since he's traveling and she deserves some finality with respect to her answer, I'd prefer not to take it under advisement if I can avoid it.
Whatever the court wants to do, we're good with. That's fine, Your Honor.
Okay, I'll see you in an hour.
Okay, thank you.
Yeah, so 4:30?
I know it'll be an hour. I'll see you at 4:40.
Okay.
All right. All right. All right, I'm going to address spousal. Were there any issues from the parties before we begin?
No, Your Honor.
Okay. I'm going to address spousal support first. ORS 107-105 1DC delineates the factors the court should consider in awarding spousal maintenance, which include those factors that were laid out nicely by Ms. Young: the duration of the marriage, the age of the parties, the health of the parties, including their physical, mental, and emotional condition, the standard of living established during the marriage, relative income, parties' training, employment, parties' work experience, financial needs, resources, tax consequence, custodial child support responsibilities, and any other factors the court deems just and equitable. The factors are viewed in totality in assessing what is just and equitable, and the court knows from having read prior case law. Hello, Judge.
You can join in.
That no single factor is dispositive. Okay. In any given case, obviously those factors would be weighted differently. I'm going to take these one at a time, and some I'll give short shrift simply because they weren't really, as the case law says, as dispositive, or didn't really create a lot of question in the court's mind. I do find that this was a marriage of long duration. It was a marriage of roughly 17 years. I know that there's a rule of thumb that all the parties are aware of, and that's that, and I know a lot of judges employ it and have heard this rule of thumb, that you take half the duration of the marriage, and that's the period of support. It's also been pounded into this judge's head that there is no such rule of thumb. That's not what the law says. And I suppose that in a system such as ours, where there's just not a lot of guidance, we do have, and there's a grid that was in respondent's trial memorandum, and it's grids like this that are helpful, where we see what the Court of Appeals has done in other cases, where we can kind of determine and get a sense of what is fair under the circumstances. I'll just say at the outset, this isn't part of my presentation, but I'll just let the parties know that this is not a rule of thumb case. It's not half case, and I'm going to make findings consistent with a judgment that orders spousal support for a much longer period than the 1/2 rule. I have, I don't know if this is something the court should admit or if I'm inviting an appeal, but I did consult out-of-state calculators, but only after I had come to my conclusion. I have my own methodology in math. I do weigh equities, and I'll go into that in just a minute, but I did consult a few other states just to see if I was way outside the realm of reason, or at least what's been reasonable in other jurisdictions. And I do think that what I'm about to order is in fact reasonable under the circumstances. I also considered the cases that were cited to me by the parties. I found some to be less helpful than I had expected when they were cited to me, and some that were even actually more on point than I had expected, where the facts really were kind of near these, but for their age, even the incomes of the parties were similar. Okay. The next factor is the age of the parties. I find that the parties are at the midpoint in their lives. He is 40, I believe it was 41, and she's 42. I also consider, when looking at the age of the parties, the remaining time to achieve education and build further career, but more on that later with respect to petitioner. With respect to the health of the parties, I think much of the controversy in the case swirled over this particular prong. In the end, I mean, I could go through all the arguments and the facts back and forth, but ultimately it comes down to this. I did find Dr. Anderson's testimony highly credible, specifically that portion where, well, first of all, I do find that wife suffers from post-traumatic stress syndrome, anxiety, and major depressive disorder to such an extent that she cannot maintain employment. I'm not saying not wholesale she can't maintain employment, but not as would be expected for a person to whom the court would normally impute a minimum wage type income for purposes of calculating, spousal support. This isn't like a child support calculation, so I'm just suggesting that if she could work, she's definitely on a spectrum where she's above those who are dying of cancer or have a deteriorating disease, as Ms. Brown pointed out in her argument, but she's certainly able to earn some income. But I think in the grand scheme of things, that number from the court's feeling from the evidence is closer to zero than it is to anything like a minimum wage computation, especially since I don't believe she can hold down work. Dr. Anderson did say, he said that wife can maintain employment with the above diagnoses. I think with treatment and medication that's possible. I did not interpret that statement to mean that she could maintain employment in a way that a person without these diagnoses could. There was some argument about gamesmanship, suggesting that the timing of the assessments. I'm not going to get into that at all. In the end, I found that there was credible evidence for her disability. In fact, I hadn't planned on mentioning this, but I will note for the record that even during her testimony, she was on the stand for quite a bit of time, I couldn't help but notice that she used one hand. I think it was the left hand that she didn't use at all. It stayed at her side. And so even though she was gesticulating actively while she spoke, she never raised that right hand, not once, not even by mistake or even in thinking, which I thought was interesting. And it was suggestive of, in the sense, her demeanor while testifying corroborated evidence of a stroke that had been as debilitating as she said it was. Am I speaking too quickly? I know we're short on time.
Nope.
Okay. So in the end, the suspicious timing of those assessments, I'm just otherwise convinced that the diagnoses are defensible and likely accurate. She has a real disability. I also find that the fact that she received Social Security, and then the testimony about contractors that I heard from Miss Elijah, where she balled up into that just struck me as, these aren't facts that are made up, and that kind of anecdotal information is helpful in understanding the extremity. Specifically when I have a witness who is telling me that she kept using the word extreme over again in how she diagnosed the PTSD, anxiety, and depressive disorder. But extreme means nothing unless it's really understood in real life circumstances. Two people arguing outside her home puts her in a closet, and she can't suggest that this is not a person that could enter the workforce without really losing that employment, not being able to cope very well. Also, the filing of the stalking protective order for aggressive handwriting, it told me a couple things. I think that was a double-edged sword for Ms. Brown. On the one hand, it just made the petitioner look absolutely ridiculous that somebody could say this handwriting is, and of course, there weren't a lot of facts adduced about that, so I don't want to put too much stock in it, but the reality is it made me believe this is a person who doesn't perceive reality closely, accurately, like, a person without these disabilities, but it also lends credibility to the fact that there is this type of disability where she's not perceiving reality accurately. And so in the end, it cast a lot of doubt about whether or not the abuse was actually real or occurred, at least in the mind of this judge. More on that in a second, but it certainly supported her efforts to prove to the court that these disabilities are real and that they are debilitating. Next factor is standard of living established during the marriage. I agree with respondent that the parties were living beyond their means in a manner that was not defensible. I thought Ms. Brown's argument was really persuasive, especially when I look through the exhibits and I see just how much debt they were amassing. And it looked like that was a situation that was occurring prior to the separation, when the court would expect that all of a sudden expenses are going to double in a lot of regards. And so I specifically found that the testimony on this point was credible from the respondent when he testified, and could not really be refuted by petitioner simply because she's not one that controlled the finances that could have given me that information anyway. The next factor is the relative income and earning capacity of the parties. Husband's income, I believe, will increase somewhat. I think overall, though, it'll probably remain likely static. I know it will decrease once his, I forgot the term that Ms. Brown kept using. I think it was CPAY is the colloquial term, but I am convinced that once he leaves San Diego, and that's an inevitability that's going to happen, hopefully sooner, because that's what he wants, but maybe later, based on the fact that he has some work to do down here, based on the allegations that were made. But I'm convinced that his income will drop somewhat, but I am convinced on the numbers that he will at least be making it a minimum when he comes back. At any rate, There's some evidence about him pursuing his master's degree with little evidence about how this would actually affect his income either way. I don't believe that if he were to achieve a master's degree and that would increase his income, that would be in any way attributable to wife's contribution. Wife's earning capacity is essentially non-existent at this moment. I looked, I think petitioner's exhibit number 2 was incredibly helpful to the court. I mean, just for kicks and giggles, if that's the legal term, I took her income over the last 32 years. I think it only went up to the last 2 years, and then her testimony I found credible that she hadn't really made any money in the last 2 years. And then I took the total number, I divided it by 32 just to see, even though it was weighted more on some years and some years were zero, just to see what her average yearly income was over the last 32 years. That number is $1,753 or $146 per month. And so again, if I do find that she can work and that she could work more than she has been, I mean, even so, I think that would produce a negligible result on the court's ruling. All right, the next is training and employment skills. I won't spend a lot of time on that. Financial needs and resources of the parties is the next prong. There was some quibbling about the parties' respective USDs. I think the parties were largely in agreement. Wife used expenses that are also claimed by husband, but in the end, I think that Ms. Brown is correct, that ultimately wife's expenses currently stated are probably accurate for the wrong reason, but will be accurate once she, once the charitable environment that's been provided by the Elijahs runs its course. I find that wife receives just about $976 per month. And in addition to that, she receives about $400 in food stamps. There's maybe some other sources of income that are negligible, like money left over from Pell Grants, but I choose for policy reasons to disregard that simply because I know that money is intended for things like books, and there was no evidence about what that remaining money had been used for, or whether it was earmarked for other school things like school supplies. But when you're online, I assume it's all just on the computer, but I don't know if I can actually make that assumption for purposes of my findings. I find that husband's income will be just shy of $11,000 per month. I think for purposes of spousal support calculations, it wasn't necessary for me to come down to the nickels and dimes of what he's going to make. But I think that, even accepting his version, and I do actually find his testimony credible on that. His net pay in the end, I do believe, will be about $8,500 after expenses. I'll skip the work experience. I don't know if I have to make any findings that will be really dispositive of any issue, but financial needs and resources of the parties, tax consequences to each party. I do acknowledge the 2019 change so that the money's taxable to as to respondent as opposed to petitioner, unlike 4 years ago. Custody and child support responsibilities, I did consider that, and any other factors. With respect to any other factors, I did look at the fact that husband should be credited for 1 year of court-ordered spousal support that he's paid already. And so I did come to a number, and then I reduced that number by 1 year. Age of the children as it affects ability to work and the intensity of their needs. That was something I looked at. I just felt like that was something that should weigh in the equities. The party's proximity retirement age was another thing that I considered, although that might also fall into the age prong. I considered husband's role in either perpetuating or exacerbating wife's mental health conditions. And that was, I assume, the party's reason for discussing at length the abuse or the allegations of abuse. And so I considered his role if he essentially somehow curtailed her ability to breadwin in her future, then that would certainly be a factor that the court should consider. In the end, however, I did not find strong evidence of purported abuse. I actually accepted it could be that I'm getting this wrong, but just based on the evidence that was presented at court, I do not find strong evidence for that, and so I didn't put a lot of stock in that, but I did consider it. All right, so after looking at guidance from case law and studying Ms. Brown's, I didn't go through each case. I will say that I didn't utilize the time to double check Ms. Brown's numbers when it came to what was represented in each of those docket numbers. I accepted those. She's an officer of the court, and I accepted those numbers. I also read the cases that were provided by Ms. Young to wit. I looked at the Uday case. I'd spelled it wrong. It looks like you spelled it wrong too. There's an H in there, so it made it difficult to find. But I found in remarriage of Tim and the Morton case. I didn't find that the Morton case was particularly helpful. At any rate, I do find that when there's a basis for an indefinite award, it usually features facts that are somewhat more compelling than the disabilities that were recited here. For that reason, I am declining to award indefinite support. What I am awarding, however, for anyone celebrates, I'm awarding $1,600 per month for a period of 8 years. That will then be stepped down to $1,300 per month for 8 years, after which support will terminate. I will make a record of how I arrived at that number without getting into all my specifics. I don't know to what extent I'm required to show my math for appellate purposes, but I will say that I did look at the request for 8.5 years that had logical appeal to the court. However, based on the fact that this is not like those cases, and I do find that there's strong similarity to those cases where the Court of Appeals gave their imprimatur to indefinite awards, I opted to look at the parties' life expectancy in the event of an indefinite award. I think it's 79 for women and 73. That's kind of extrajudicial, but just looking at that roughly and knowing that each party has roughly 30 years of life, and then looking at midpoints and reducing based on equities and giving them credit for a year, that's how I came specifically to those numbers. I did consider all the other things, including their monthly expenses, to fashion an award that I thought would put them at a midpoint between his earning capacity and what I believe her low income capacity would be. And so I think that this is designed to equalize their situation as best as the court could manage under the circumstances. Any additional findings required, Ms. Brown, with respect to spousal support?
No, Your Honor.
Any additional findings required from petitioner?
No, Judge.
All right. Are there any other findings that I neglected with respect to the property division? I can go down them one by one and make specific fact findings, but in the end, I don't know if that's necessary.
I'm fine. Yeah. No, that's fine.
All right.
Your Honor, I know it's late, but I foresee Ms. Young and I getting into an issue later.
Sure.
And so I just assume just throw it out there now. So,
With respect, are you talking about retroactivity or?
No, I'm assuming this starts October 1. Yeah, and we've satisfied up until October 1.
Okay.
Okay. But with regard to the judgment, there was a line, husband's abuse of wife during the marriage exacerbated wife's disability. I just heard the court say that you didn't find
let me
strong
clarify.
evidence.
I said I considered whether the allegations of abuse exacerbated or what was the use of the word, perpetuated her inability to, I think the word I used was breadwin. I don't even know if that's a word, but it is now. I did not find credible evidence to support that. That was an argument advanced by petitioner, and I thought that there was insufficient or a dearth of evidence in the record to support that specific finding. So,
Thank you, Your Honor. There's a line in the judgment that requires husband to notify wife of changes of employment, provide full tax returns, and if he fails to do that, then there's a sufficient change in circumstances warranting a request for modification. I would suggest that language shouldn't be in there because there's a whole procedure for how to do modification that doesn't state that.
Ms. Young?
The original reason for us including that is that wife has no way of knowing if his employment changes. And so, well, I can tell you if he retires, we'll certainly file a modification so she would know then. But otherwise, it's all through Division of Child Support. That's not language that would typically be in there.
Is she correct that, again, I'm the newcomer to this corner of the law. Are you in agreement with her that this is language that's not typically seen in judgments?
Yes, Judge.
All right. Okay, then we'll omit that language.
All right. They're requesting 1/2 of the children's school expenses paid by either party. Your Honor, I submit to you that's what child support is for.
1/2 of school expenses. Counsel?
That's,
I know this is unorthodox. We didn't really address these issues in our.
Yeah.
I just don't want there to be a problem.
I understand. No, and I appreciate, let's do it now rather than later.
I think that's intended to address like special school field trips, so things that are kind of above and beyond extra expenses.
Leave the language. I agree with Ms. Young. What's the next issue?
Well, it's not above and beyond, it's basic school expenses, activity
But it
fees,
includes special
photographs.
field trips.
Leave the language.
Let's see, we took care of their savings plan. With regard to retirement benefits, it should be date of marriage to date of separation.
Counsel, any argument?
Just that the standard is in Oregon is typically date of dissolution. I know that
Is she right? She argued about that in her closing, and I neglected, and I didn't have, I spent all my time researching the spousal support
There's
question.
actually a case on point, Your Honor, that has to do with husband's military retirement. Parties were separated for 2 years. So of course they looked at equal contribution. Wife, of course, didn't contribute, and that was awarded to husband.
And it was a time of separation, correct?
Yeah, in that case, parties had been separated 3 years, but it was husband was overseas for 1 year. The parties were still working together, commingle finances,
I'll
things
say
like.
this, prior to you citing the case law, Ms. Young, or suggesting that that was the norm, they had adduced evidence through husband that he had paid significantly following the date of separation. I see the appeal of both approaches, but I'm inclined to side with Ms. Brown that it should be the date of separation, unless, if I'm patently wrong and you think that if there isn't a split of case law, then perhaps I would welcome, or I would entertain a motion to reconsider that issue if we've got additional case law. But if it's left to judicial discretion and judges, just follow the equities, then I will, that's how I'm going to rule on that issue. Ms. Brown, anything else?
Yes, there's a blank for spousal support life insurance. Husband's agreeable to do $100,000 for child support for the children, $100,000 for spousal support. In addition, wife's getting a survivor benefit plan with regard to the retirement account anyway.
Okay.
And I think those were the only outstanding.
All right, now, Ms. Young, any issues with respect to the judgment? It sounds like Ms. Brown is volunteering to draft it, the judgment.
We should be good. I had already drafted
We're
it.
okay.
So I
think we can work it out. I just didn't want there to be a problem
I'm
on
sorry,
those issues.
and I know it was in there, but I couldn't remember who had drafted the proposed judgment. It was Ms. Young. So, Ms. Young, you're directed to prepare a judgment consistent with the court's findings. I think it should be easier for you since you have one. You just have to modify a few paragraphs here and there. Keep it cheaper for the clients. Any other issues?
I believe that's it.
Nothing more, Your Honor.
All right, thank you.
Thank you. Appreciate your time.